Hello, everyone. I am Elizabeth Samples. I'm a partner in Husch Blackwell's Education Group. I'm located in the Kansas City office, and I've been a member of the Education Group for 9 years. Before joining Husch Blackwell, I served as an attorney for the U.S. Department of Education's Office for Civil Rights. And with that background, advise many of our clients on issues related to civil rights compliance, including disability accommodations and accessibility compliance. So thank you so much for joining our program today. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. Also, please note if you hover over the videos, there is an option to activate the platform's closed captioning function. If you have any questions during the webcast, please submit via the question box. We will try to answer questions during the webcast as we're able, but if a fuller answer is needed or if we run out of time, we will connect with you via email to address your questions. And a PDF of the presentation is available in the program materials folder. And the program has been approved for legal education hours. For live attendees, you can report your hours by clicking on the CEU icon at the bottom of the screen. And a certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And towards the end of the program, be sure to complete our short survey. We do use your feedback to plan for future programs that are applicable to your institutional needs. That's all for the housekeeping items. So let's get started with our program. Joining me today is Marissa Hadajak, an attorney in Husch Blackwell's Education Group. Marissa previously served as an in-house attorney at a major public research institution, and she now works in our education group on investigations, compliance efforts, and litigation, including issues involving ADA and Section 504 compliance. So thank you, Marissa. And now just want to walk through our agenda for the hour. Marissa is going to start us off by talking about some background related to relevant laws and some proposed legislation related to accommodations and accessibility. And then we're going to take a deeper dive into a few targeted compliance areas. We're going to focus on digital accessibility, emotional support animals, private room accommodations, accommodations in clinical programs, and direct threat assessment. And then if we have time, at the end, we will walk through a brief scenario. So without further ado, I'm going to turn it over to Marissa to talk about relevant laws.
Thank you, Elizabeth. And that picture from a couple of slides ago was from before I had bangs. So that's funny to see. That was a different person, different time. But I'm going to be starting with everyone's favorite part of the presentation, which will be talking about the relevant laws. So first, we will be going through a poll question, and it is, what laws are relevant to university accommodations and accessibility issues? Is it the ADA Section 504, Section 508, the Fair Housing Act, or all of the above? And I'll give you all a moment to put in your answers. Okay, we're at about 44% of people put it in, so I will move on to the next slide. And looks like most of you are correct. It is all of the above, and that was kind of a tricky question because Section 508 was probably going to trip up some of you, but we'll talk about that in a few slides. So as mentioned on the previous slide, the key disability laws are the Rehabilitation Act, which includes Section 504 and Section 508, the Americans with Disabilities Act, the Fair Housing Act, and then also state and local laws. So to start, Section 504 of the Rehabilitation Act, this was the first statute to require disability accommodations, and it was enacted in 1973. And this makes it illegal for the federal government, federal contractors, and any entity receiving federal assistance to discriminate on the basis of disability. And it states in relevant part that no otherwise qualified individual with a disability shall, solely by reason of his or her disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity. And because Section 504 applies to any entity that receives federal assistance, it more likely than not probably applies to most of you, both public and private institutions. And then next, we have Section 508 of the Rehabilitation Act. And this requires federal departments and agencies that develop, procure, maintain, or use information and communication technology to assure that these technologies provide access to information and data for people with disabilities. As background, in 1998, Congress amended the Rehabilitation Act of 1973 to include Section 508. And Section 508 clearly applies to electronic and information technology procured by the federal government, which includes computer hardware and software, websites, phone systems, and copiers. So essentially, under the law, agencies must give disabled employees and members of the public access to information comparable to the access available to others. And on January 18th, 2017, the U.S. Access Board published a final rule that revised and updated the Section 508 standards, along with accessibility guidelines for telecommunication products and equipment covered by Section 205 of the Communications Act. And compliance with Section 508 base standards began in January 2018. And so the reason that this is relevant to colleges and universities is because entities that are subject to the ADA, which I'll be going into detail in the next couple of slides, but entities subject to the ADA have long looked at compliance standards under Section 508 as the model for compliance, as this is what's expected of the federal government. And now on to the ADA, and I'll be going through Title I, Title II, and Title III of the ADA. So first, Title I, this prohibits private employers from discriminating against qualified individuals with a disability regarding employment. And qualified individuals are those who can perform the essential functions of the job with or without reasonable accommodation. And employers are required to provide reasonable accommodations to qualified individuals with a disability who can perform the essential functions of the job with or without accommodation, but not if such an accommodation would constitute an undue hardship. Next, we have Title II. This prohibits disability discrimination by public entities. So those of you on this call who are at public institutions, Title II most likely applies to you. And it states that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subject to discrimination by such entity. In a public entity's programs, activities, and services, viewed in their entirety, must be readily accessible to and usable by persons with disabilities. And finally, we have Title III of the ADA. This prohibits places of public accommodation from discriminating on the basis of disability and the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation. And colleges and universities are places of public accommodation. They must make reasonable accommodations in policies, practices, and procedures. And I think there's construction going on directly above my office. So if you hear anything weird, that's what's going on. Okay, and then next is the Fair Housing Act, which this is one that sometimes gives people pause because it's not as readily apparent how or why the Fair Housing Act would apply to colleges and universities, because the Fair Housing Act requires reasonable accommodations to afford persons with disabilities an equal opportunity to use and enjoy a dwelling. And a dwelling is any building, structure, or portion thereof which is occupied as, or designed, or intended for occupancy as a residence by one or more families. And this applies to colleges and universities because the Department of Housing and Development and the Department of Justice consider dormitories to be dwellings. So if you have campus housing or if you have student housing, then the Fair Housing Act would most likely apply to that housing. And this has also been seen in the courts. There's been some litigation around this, and the district court decisions are in agreement that dormitories are dwellings under the Fair Housing Act. And then state and local laws are can be relevant to accommodations and accessibility issues because most states and major cities have anti-discrimination laws that mirror, or in some cases are more stringent than Section 504, the ADA, and the Fair Housing Act. And these statutes generally prohibit discrimination on the basis of disability or perceived disability, and they generally require some manner of reasonable accommodation. And these laws may set a lower threshold for establishing the existence of a disability or its effect on a major life activity. So to recap, the general principles of the key disability laws are no disability discrimination in employment, no disability discrimination in programs and activities, no disability discrimination in places of public accommodation, accessibility for facilities and services, and reasonable accommodations and modifications. So what is covered by these laws? It's a lot. It includes programs, benefits, and services, which that includes admissions and recruitment, academics, financial aid, housing, counseling, athletics, transportation, employment assistance, as well as communications and facilities. What is the process to obtain an accommodation? And this is just kind of a high-level overview of the process. At your institution, it's most likely more nuanced, but typically the process begins with self-identification of disability and then a need for accommodations, and typically submitting some sort of medical documentation. And then the institution will review the medical documentation and then engage in what's called the interactive process to determine whether and to what extent accommodations are made. And then these accommodations are provided on a case-by-case basis based on the outcome of an individualized interactive process. And you're probably going to get sick of hearing that term in this presentation, but we will reiterate case-by-case individualized process. That is key to this. So what is a reasonable accommodation? Well, this is everybody's least favorite lawyer answer, but it depends on the nature of the disability, how the disability limits the person, and the fundamental requirements of the program and the activity at issue. And some common accommodations include extension of deadlines, more time for work and tests, time for medical appointments, recorded lectures, and note takers, but this is by no means an exhaustive list. And there isn't, a magic formula for if someone has a specific disability, then they get, X accommodation. It really does depend on the situation and the particular facts of the case. So what rights do students have to challenge the decision of the institution? Students have the right to file a grievance or a complaint when the student believes reasonable accommodations should be granted but were denied, when the student believes that accommodations have not been implemented properly. So, for example, if a student receives an extended testing time accommodation and then they go to their course, they try to get the extended testing time, but the faculty member doesn't give them the extended time, they don't implement it, then this student would be able to file a grievance or complaint saying their accommodation hasn't been implemented properly. And then finally, when the student believes that they've been discriminated against based on their disability.
And Marissa, I was just going to jump in here and just share kind of a practical point related to this grievance process and why it's so important, from an institutional standpoint. So first, it is required that there be some sort of grievance process related to these issues. And second, in an effort to provide good student support, right, having a process for students to communicate issues that they're experiencing is good practice. But also, when it comes to potential complaints to the Office for Civil Rights related to disability accommodations, it can become really important for an institution to be able to demonstrate that they've already had an internal grievance that they've addressed through their grievance process, because OCR has a dismissal provision that allows an institution, to provide information about a complaint that's already been raised and already been reviewed. And assuming, the institution can demonstrate that it was handled and reviewed under sort of similar framework to how OCR would view it, then the institution is putting itself in a good position to potentially have that matter dismissed, from a full sort of formal OCR investigation. So that's another reason why sort of clear publication about grievance procedures and adherence to the grievance procedures can be really important from an OCR standpoint as well.
Thank you, Elizabeth. That's very helpful. And that ties into our next slide, which just briefly touches on OCR enforcement, which I wanted to note because later on in this presentation, we're going to be going through some different OCR letters. So the Department of Education's Office for Civil Rights, or OCR, it investigates complaints of discrimination and noncompliance made against educational institutions. And I just wanted to note that disability-related complaints are on the rise. So now I'm going to go through some proposed legislation. Starting off with Title II of the ADA, the Notice of Proposed Rulemaking for Web Accessibility. In August 2023, the DOJ published a Notice of Proposed Rulemaking, or NPRM, for Title II of the ADA related to web accessibility. And specifically, the NPRM aims to improve web and mobile applications access for people with disabilities and clarify how public entities, primarily state and local governments, can meet their existing ADA obligations as many of their activities shift online. And the proposed rule would set the Web Content Accessibility Guidelines, WCAG or WCAG, as the standard for compliance for state and local governments that are covered by Title II of the ADA. And this rule will apply to public universities and community colleges. The final rule was anticipated in April 2024, so, not too much longer. And currently, the online tracker for regulatory actions currently under review by agency states that the final rule was received on January 22nd, 2024, and it is pending review. Some key points from the Title II ADA NPRM. The proposed rule would adopt the internationally recognized WCAG 2.1 Level AA technical standards for web accessibility. And the rule also clarifies that both websites and mobile apps must comply with the technical standard. And the proposed rule also contains some narrow exceptions for compliance with the technical standards for some types of content, such as web content that is archived or content that is posted by a third party. And there are several other exceptions on there, but we're not going to go through those in this presentation, but I do encourage you to review those online. And then the timeline to comply with the final rule is proposed to be 2 to 3 years after the final rule is published, depending on the size of the state or local government. And so this is from the ADA website, and it states that for state or local government entities that are under 49,999 persons, they would need to comply 3 years after publication of the final rule. And the same goes for special district governments. But state or local government entities that are 50,000 or more persons have 2 years after publication of the final rule. We also wanted to discuss the proposed regulations for Section 504 of the Rehabilitation Act, because in May 2022, the Department of Education announced that it would be updating the Section 504 rules. And in this announcement, the Department of Education noted that since 1977, there have been very few changes to Section 504, despite the fact that the world has undergone enormous changes since that time. And many anticipate that the proposed rule will update Section 504 to align with the ADA, to clarify Section 504 against the Individuals with Disabilities Education Act, and to address mental health issues and remote learning, just to name a few. And the proposed rule was anticipated in August 2023. However, we are still waiting, and the Department of Education has not announced a release timeline for the rules. But this is something that we just wanted to put on your radar if you weren't already aware of it. So next up, Elizabeth is going to be going through our first compliance area.
Thank you, Marissa. And before we dive into some of the particular areas, we're going to launch our next poll question. We have included the 5 topics that we plan to talk about here in the next several minutes, and so wanted to get some information from you about any that you believe are, of significantly pressing nature at your institution or that you've been dealing with sort of more frequently. Where is your institution encountering the most issues among this list? And we've also included an other category if that more accurately describes what you've been grappling with. And so in kind of looking at some of our results, we're seeing about a quarter of you addressing accommodations in clinical programs. A quarter have identified web accessibility as an area of significant attention lately. And then also emotional support animals is among the higher ones as well. So thank you for your feedback. And now we'll dive into talking about these areas. So with respect to digital accessibility, want to, of course, first highlight that this is a common issue facing institutions of higher ed in the recent past, but is still very much a developing area of law, and a lot of issues remain unsettled with respect to digital accessibility. As Marissa highlighted in talking about some of the proposed legislation, when we think about the ADA and its passage in 1990, the internet was still very much in its inception at that time. And so there is nothing particularly in the regulations at this time that addresses digital accessibility and technical standards, which is why there have been sort of increased pushes for legislation in this area so that institutions know what they need to do in order to comply in this area. In addition to some unsettled law related to applicability of digital accessibility standards, compliance can also be really difficult in this area because of the nature of the web itself. There can be a vast number of institutional web sites and web pages, and in our experience, particularly at some larger institutions, the operation of the website can be decentralized so that ownership and control over digital content is not centralized, which makes it harder to sort of monitor and put controls in place. And it can also be difficult at times to coordinate with relevant IT staff and administrators and faculty, again, to sort of focus on compliance issues in this area. And then in some instances, due to some of the factors above, some schools are at times sort of unaware of even the issues related to this area until a complaint is filed with OCR. So in recent years, there has been an uptick in OCR enforcement in the digital accessibility space, including OCR identifying a dedicated team of attorneys and investigators who are now trained and tasked with enforcement in this area. As some of you may be aware, an advocate filed mass complaints with OCR against educational institutions across the country, in many instances, using sort of automated testing to identify technical barriers on the public-facing website, and then submitting complaints with OCR related to them. Many of those complaints were dismissed initially, but then following some litigation were reopened. And then several of those have been resolved through remediation and through resulting 302 agreements. And then in May of 2022, OCR proactively launched 100 compliance reviews regarding digital accessibility. And the reviews looked at accessibility in public and student-facing websites and other educational platforms maintained by the institutions. And then finally, wanted to make sure to bring your attention to a DOJ and OCR joint Dear Colleague letter issued May of 2023, addressing enforcement activities related to digital accessibility. And in that Dear Colleague letter, OCR talked about resolving and monitoring more than 1,000 cases in recent years related to digital access. So we've had some questions in the chat about the reason for increased disability related complaints at OCR and their enforcement. This is a part of that, right? There are, of course, other aspects to the disability laws that we're talking about that result in OCR enforcement, but certainly part of the reason for the increase is because of these digital accessibility matters. So when we consider OCR's enforcement, when we look at some of the resolution agreements and from some of our experience in helping clients with these issues, there are some clear components of digital accessibility compliance that OCR focuses in on in their reviews. And so that can be helpful as institutions are thinking about their compliance in this area. So just as kind of background to kind of narrow in on some of those areas. So one of the areas that is frequently focused on is keyboard navigation. So for a person with a mobility impairment who's unable to use a mouse, but instead uses a keyboard to navigate a website, is that individual able to effectively utilize the keyboard to navigate through the website? And does the website have the structures in place that allow for that effective navigation? And then when an individual is using keyboard navigation, are there visual indicators that help the individual to understand where they are on the web page? And then another component that OCR frequently focuses in on are links and whether they are meaningfully labeled or titled so that a person who is using a screen reader can understand the functionality behind that link. And then finally, we know that PDFs are fairly prevalent in academia and across institutional websites. And so one of the areas that OCR focuses in on with respect to compliance is whether PDFs are accessible to individuals who are using a screen reader. And again, that ties to structural components within those PDFs. So on the case law front, we wanted to sort of highlight that there is a split currently in the circuits as to how the circuits interpret ADA and their applicability to websites. And so the holdings can generally be sorted into two main categories. Those who assert that websites are not places of public accommodation subject to the ADA. And those who conclude that websites are places of public accommodation. And then along this continuum, there are some courts that hold that websites are places of public accommodation when certain conditions are met, such as when the website has a physical nexus to a brick and mortar location. So you can see kind of a summary of some of those cases on the slide. And so the key there is, we're seeing increased litigation across industries under Title III of the ADA and applicable state laws. And so you might consider, at your institution, what sort of jurisdiction that you fall into with respect to potential threatened litigation. But what is clear, again, from the previous slides is that from OCR's enforcement standpoint, they are utilizing their jurisdiction under Section 504 for both public and private institutions, to consider digital accessibility from a disability discrimination standpoint. So a few kind of compliance points here to consider when thinking about digital accessibility. So one of the first things that we recommend is that institutions assess their online presence. How many web pages, websites do you have? Are you operating? And what links do you have to third-party websites? We are seeing a recent wave of litigation and demand letters to institutions related to third-party websites that the institutions link to for example, the sale of sports gear and sportswear affiliated with the university. So it's important to think about, not only the university's domain, but also the sites that the university links to, and consider, the contracts that are in place with respect to those third-party websites and what kinds of assurances those provide the institution about accessibility compliance and how non-compliance or barriers that are reported will be addressed. Also consider what kinds of social media platforms the institution is utilizing. OCR has included social media platforms in its enforcement in this space. So making sure when kind of taking an inventory about accessibility and about controls over accessibility functions, what social media platforms look like at the institution. And then gather information from your internal team and external partners. Evaluate what kind of internal talent you have to address this compliance issue. A lot of times we know there's sort of capacity issues, right, in terms of the various hats that individuals are tasked with wearing. But, who do you have internally that can be tasked and perhaps trained, to focus on these digital accessibility pieces? And then if there is a lot of decentralization across website operation, what kinds of institutional decisions might we need to make about centralizing that so that we can implement some of these controls? Establishing a website accessibility policy can be important to sort of communicate to community members about the commitment to accessibility, and also to provide a grievance process or a complaint process through which individuals can identify barriers that they're experiencing, giving the institution an opportunity to address that internally to hopefully avoid future complaints. And then evaluating web content, which can include both manual and automated checks, is an important step in considering how you might address digital accessibility from a compliance standpoint. And remembering that when prioritizing remedial efforts, thinking about high traffic websites first, thinking about really important student facing websites first, like Disability Services website, kind of considering, again, prioritizing some of those sites. And then also focusing in on individualized complaints that may have been made. If there have been, complaints, again, about particular barriers on particular sites, making sure that the institution is addressing those. And then thinking about low-hanging fruit that the institution might be able to address, issues like captioning or alt text, and also thinking about sort of remediation that might be able to be implemented more broadly. Some of these are about structural issues behind the scenes in the website, and identifying a structural issue might sort of address a barrier more globally from a template standpoint. And then consider training. Systems and controls in this area can only go so far. So building on the knowledge of your internal web team and helping to train them, and then maybe have some sort of train the trainer model where individuals are training others at the institution, particularly those who have permissions to modify and add content to the website. Again, those are some compliance points related to digital accessibility. And with that, I'm going to turn it over to Marissa to talk about emotional support animals.
Thank you, Elizabeth. So I thought about adding pictures of my own cats on this slide, but I figured that I'll save that for the next presentation. So hope you enjoy this stock image of a calico. But emotional support animals. Many institutions are increasingly facing issues related to students and emotional support animals, or ESAs for short. And emotional support animals provide therapeutic emotional support for individuals with disabilities. And they may be a reasonable accommodation for students as required by the Fair Housing Act for campus housing. And in contrast to service animals, which could only be dogs or miniature horses, ESAs are not limited to dogs and miniature horses. And so schools are seeing requests for all types of ESAs. You name it, cats, bunnies, snakes, chickens, people are requesting a lot of different things. However, an ESA must still be requested through the interactive process. And some areas that institutions are encountering related to ESAs are that, first, there's been an influx of students requesting ESAs, which we don't know exactly why, but it could be attributed to a rise in mental health issues among our student populations. And another issue that we've seen institutions grappling with is how to handle student medical documentation for an ESA that is clearly from a website that charges a standard fee for a boilerplate letter regarding a student's need for an ESA. So say it's like $100, they don't meet with this medical provider, there's just a generic letter that's generated. And some institutions don't want to accept these types of letters on their face as sufficient medical documentation, but they're not really sure how to proceed with this. And so HUD has a helpful guidance document online that addresses this issue, and I'll touch on this in a couple slides. but this is an issue that we've seen institutions facing. There are also sometimes issues related to an ESA's behavior, such as an animal that's roaming the hallways of the dorm or an animal that's displaying destructive behavior in the student's room. And schools may struggle with accommodating a student's disability while also protecting the school's property and protecting other students. And similarly, issues sometimes arise with competing disabilities in the realm of ESAs. For example, two students might be assigned to the same dorm room, and one student has an accommodation for, say, an emotional support cat. Then the other student who's in the dorm has a severe cat allergy. So it can be difficult to juggle these competing disabilities. And then finally, students who are given an ESA accommodation might sometimes want to take their ESA to other areas of campus, such as class or the cafeteria, and schools might have difficulty determining if and when a student can take their ESA outside of their dorm. When it comes to assistance animals, generally, whether it's an ESA or a service animal, OCR does have jurisdiction over these issues, and there's been more investigation and resolution related to service animals that we've seen, but there is some related to ESAs as well. And so in a 2018 OCR resolution letter, a complainant alleged that a university discriminated by impermissibly inquiring about service animals, and that the university had a policy that stated ESAs are only allowed in university housing, so that they couldn't leave the students' housing. And OCR found, with regards to the ESA issue, that the university did not have a specific policy on ESAs, but there was a form for requesting an ESA in university housing that said that ESAs are limited to student housing, that they are not allowed in places of public access. And OCR would expect the university to engage in a reasonable process with the student, which would include reviewing ESA requests on a case-by-case basis and reviewing accommodation requests as it would for other types of accommodations. And so the lesson learned here would be to avoid having a blanket policy with language prohibiting ESAs from ever leaving the residence halls, and instead engage in the interactive process and conduct an individualized assessment for such requests. So some compliance points that we have related to emotional support animals. First, develop a policy that addresses ESAs. This could either be a standalone policy or maybe one in conjunction with the service animal policy, or it could be embedded within a larger accommodation policy. And we recommend setting standards for specific medical documentation that is permitted, and consider how you will handle documentation that comes from websites that I mentioned previously that charge a minor fee to write a generic letter. And in the online guidance document from HUD, they noted that in its experience, in HUD's experience, such documentation from the internet is not by itself sufficient to reliably establish that an individual has a non-observable disability or a disability-related need for an assistance animal. So something to take into consideration. We also recommend avoiding blanket bans, like I mentioned, such as prohibiting all types of a certain animal, say no emotional support animal, snakes, no tarantulas. We recommend avoiding that. And as always, engage in the interactive process and conduct assessments on an individualized case-by-case basis. We also recommend training housing staff and administration on relevant issues, because these individuals are the most likely to have to enforce compliance with your school's ESA policy and standards. They're the ones who will first see when a cat is, roaming the halls or something like that. Also, provide students with a grievance mechanism that allows them to challenge issues related to their ESA accommodation, such as if their ESA is removed for whatever reason, or if they've been denied an ESA. And next up, sorry if you can hear the hammering above my office. Next up, Elizabeth will be talking about private room accommodations.
We can't hear the hammering. Don't worry, Marissa. At least I can't. There were several questions about emotional support animals, which indicates that it is a pressing topic for a lot of those who are attending. So I just thought I would address a few of them quickly. Somebody asked about emotional support animals for employees. That is going to fall under Title I of the ADA, as Marissa mentioned, right? Title I is what applies to employees at your institution. And so there you would be working through whatever mechanism you already have in place, right, for employees to request disability-related accommodations and going through that process to determine if an emotional support animal is a reasonable accommodation for that employee. And then someone asked about limiting or putting limitations around the age of an animal, or perhaps requirements that an animal be spayed or neutered. A lot of animals on campus or emotional support animal policies do include requirements for, reasonable requirements for the age of the animal and it being housebroken, for example. So that is something that an institution, again, within reason, can put requirements on. You always want to be engaging in an interactive way, right? And we're always cautious, right, when we're applying bright line rules in this space, because as Marissa and I keep referencing, right, it is about individualized determinations, but there can be reasonable restrictions on, again, age of the animal and requirements that the animal be housebroken. And then there's questions about requesting medical documentation related to an ESA either in the dorm or taking an ESA to class, sort of more a reasonable accommodation in that space. And like the other aspects of the interactive process, yes, institutions can ask for medical documentation related to the emotional support animal. So with that, let's move to talking about private room accommodations. Another area where we're seeing schools encountering increased sort of requests and issues relates to private room accommodations for students. This is, of course, an aspect that falls within your already existing process, your interactive process for determining reasonable accommodations. But at many schools, standard rooms for school housing have 2 students to a room. And there may be limited private rooms available. And when there are an increasing number of students who are requesting to be placed in private rooms as an accommodation for a disability, that can, put the institution, can put strain on sort of institutional resources and decision making. So and also, private rooms are often more expensive for students to traditionally live in than a standard room. And so if we're tracking sort of OCR enforcement in this area, it's largely focused on a few different components. Number one, schools charging students fees for single rooms when it is related to a disability, providing auxiliary aids and services to students in the housing context, and then denying students private rooms due to lack of availability. So what we've done on this slide is highlight for your reference a few different OCR resolutions that walk through sort of complaints in this area and highlight, kind of how those issues were resolved. So just to kind of talk about a few of these. So in that first 2018 letter, there was an argument about the student having to provide their own air conditioning unit when needing air conditioning was a disability-related accommodation, and then failing to waive fees, permitting students to move in early, and maintaining a practice that charged a default rate for housing. And then failing to provide a disability-related single-room accommodation. So in that OCR determination, there was no findings because it was resolved through a 302 resolution agreement. But one of the things that OCR required was that the institution review and revise its policies and related to making reasonable modifications to housing policies and procedures when necessary to avoid discrimination, unless the institution can demonstrate that it would be a fundamental alteration. So while the case doesn't make a finding, it implies that the best practice would be to assist students in finding necessary accommodation equipment for their rooms, here the air conditioning, and that failing to provide a single room accommodation due to a lack of a single room in housing likely is not sufficient. So There is some language in the legal standards section of this case that sort of helps to reorient, about the requirements here. OCR states a post-secondary recipient that provides housing shall provide comparable, convenient, and accessible housing to students with disabilities at the same cost as to others, and such housing shall be available in sufficient quantity and variety. So speaking of sort of having variety, one of the things that OCR highlighted in the decision was evidence that it had of the institution engaging in a past practice of turning double rooms or triple rooms into single rooms when needed. So sort of evidence that the university could point to that it had attempted, right, to make accommodations for single room when approved. Again, some of these other resolution letters, again, may be a helpful resource to you as you're thinking about this accommodation issue. So some compliance points here. As I mentioned, this falls within the way that you typically process requests for accommodations. And so you want to make sure that you're aligned with that interactive process and what your policy dictates. But it may be that if you're seeing an increase in these types of requests, it may be that a separate policy or at least internal operating document that helps staff to understand how private room accommodations may be handled could be helpful. Training for housing staff and administration can also be really useful in this area to sort of re-emphasize that, we have our housing policies, we have our trained, dedicated housing staff, but to the extent that we're having accommodations requests that affect our residents' life, we need to be making sure that Res Life is talking with disability services. And so this can be a good kind of training point for staff in both areas, to be consulting and trained. And then considering how the application of rate policies might be discriminatory in this space and how the institution may need to make adjustments, and working with students to identify auxiliary aids and services that may be needed in the housing context. And then, of course, as always, engaging in the interactive process to identify alternatives. And, one of the key pieces here, too, is, oftentimes there can be sort of discussion and question around cost of the single room and ability to provide the single room. But remember always the first component of the analysis in the interactive process is to determine whether the individual is a qualifying individual with a disability and whether there is a disability related need for the single room. So engaging, the institution can engage in that aspect of the interactive process to really determine what the need is, the disability related need for the single room, and sort of evaluate that under its interactive process to determine if that is going to be considered a reasonable accommodation. And with that, I will turn it over to Marissa to talk about accommodations in clinical programs.
Thank you, Elizabeth. All right, so accommodations in clinical programs. This can be an area that is difficult to navigate because academic programs with clinical components such as medicine or pharmacy or nursing, just to name a few, they have unique issues related to accommodations that can make it more difficult to identify and to implement reasonable accommodations for students. So schools may have some of the following issues related to clinical program accommodations. First, clinical programs often have high demands on students in terms of professionalism and academic expectations. And additionally, these programs have technical standards that require careful consideration by professionals who have been trained in the discipline. Another issue that schools may encounter is that their clinical partners may not be as willing to provide accommodations to students for, several reasons. But so say if you have a student who is working at a hospital for their clinicals, and this hospital isn't affiliated with the university, it can be difficult to coordinate accommodations for the student in such a situation. Additionally, students may seek accommodations that result in missing clinical dates or making up or rescheduling assignments or tests, which these are typically, they can be very standard accommodations in other academic settings, but they might not always be as feasible of accommodations in some clinical settings. And then we've also seen some enforcement by OCR and some litigation related to students with their service animals and their clinicals, primarily regarding service animals in hospitals. And we'll go through a couple examples related to that. So first I wanted to talk about a 2023 OCR resolution letter where a complainant was a student who wanted her service animal to accompany her during her clinical rotations, including in a patient's room. And the university decided that this was necessary to afford the student an equal opportunity to participate in the university's clinical program. But her request was denied due to a blanket policy at the hospital that restricted students from bringing service animals into patient rooms. And OCR found that the university prohibited the complainant from having her service animal accompany her during the clinical rotations because of the hospital's blanket policy. And this raised concerns to OCR that this decision was not individualized to the specific disability-based needs of the complainant. However, this case was resolved prior to OCR completing its investigation. And then we're running a little short on time, so I'll try to go through this case somewhat quickly, but it also relates to service animals in the clinical setting. And if you want to read the full case, there's the citation at the top. But this was an Eastern District of Michigan 2023 case where the court actually found summary judgment for the medical center because, and this had to do with a student who was a clinical intern and she had a service animal that she wanted to accompany her. And in this situation, the court found that the medical center engaged in an individualized assessment and that it adjusted the desired accommodations for the student only after people reported allergic reactions. And this case was also recently affirmed by the Sixth Circuit in Bennett versus Hurley Medical Center. And so sorry I'm going through this one quickly, but we don't have a lot of time left. And then another case that I wanted to go through was a Southern District of Georgia case, which it addressed accommodations in the clinical setting. And in this case, the plaintiff was a former anesthesiology resident who was diagnosed with narcolepsy during a fitness for duty evaluation that was required as part of a remediation plan. And the plaintiff's contract was not renewed following a pattern of poor performance and tardiness, both before and after his narcolepsy diagnosis. And the resident sued the university for discrimination and failure to accommodate. And the court found summary judgment for the university and found that the plaintiff was not qualified for the resident position because he was unable to arrive on time. And this was an essential function of being an anesthesiology resident. And the court noted that because of the plaintiff's inability to show up on time on at least 7 occasions, both before and after he was diagnosed with narcolepsy, he failed to fulfill an essential function of his residency. And the court also noted that being late can have ramifications on patient safety, and therefore the plaintiff posed a threat to the health and the safety of others when he was tardy. And this case was also recently affirmed by the 11th Circuit about a month ago, actually. So some compliance points for accommodations in clinical programs. We recommend establishing a clear policy and process for clinical accommodations. And again, this could be embedded within your larger accommodations policy, but we recommend having a policy or process that speaks to this. We also recommend adopting technical and academic standards for all clinical programs, where students must be capable of meeting the technical standards for the academic and the clinical components of the program. And courts will often defer to the institution's judgment on such technical and academic standards, but these must always be applied uniformly. The standards must be. We also recommend periodically reviewing and updating the standards and then seeking input from professionals in the discipline. And we also recommend applying these standards consistently during the admissions process, because this will help ensure that your school is admitting students who are otherwise qualified to fulfill the essential requirements of the program. Additionally, we suggest conferring with relevant university officials and professionals for academic and standards decisions. And as always, make an individualized assessment and consistently document the interactive process and decision-making in these types of situations. We recommend also providing grievance procedures and training relevant staff, faculty, and administrators of clinical programs on these accommodations issues and implementation of approved accommodations. And so next, Elizabeth will be talking about direct threat assessment.
Thank you, Marissa. As we transition to spend the last few minutes talking about direct threat assessment, I thought I would try to just address a few of the questions that have been raised related back to private room accommodations. One great question was whether the university can hold to an accommodation deadline for housing requests. We would recommend that, of course, in your institutional policy, you can make recommendation or aspirational language and certainly encourage individuals to make requests early and even note, right, that sometimes if they're not requested at an early juncture, it can be difficult and there can be delay in making, appropriate assessments. But certainly I think OCR would view a bright line, sort of deadline on housing request as potentially, in violation of 504, because it, wouldn't allow a person to make, a request at any time, which I think is generally the position. And then someone else raised a question about getting, institutional pressure from finance offices and the like about decreased revenue related to, for example, private rooms or even meal plan exceptions, which is another, great issue to raise. I think that the primary response there is that, this OCR has been clear about, re-emphasizing that, institutions have an obligation to provide these types of accommodation without, cost, to the individual student, and make sure that it's, again, that housing is being provided at the same cost and they're not incurring cost related to, their disability. We have a Department of Justice resolution agreement related to meal plans that makes it clear that, when disability related, there needs to be modifications to those types of requirements. So again, would just always, reiterate making that individualized determination. And with that, I'll move to just talking for a few moments about direct threat assessment. We had fewer of you in our initial poll that indicated that this is a pressing need. And in fact, this is one that comes up, more infrequently. But when it does, it can be, challenging for institutions and the teams that are kind of comprised to deal with these issues. It can be a difficult task. So at its core, the fundamental principle is that an individual with a disability must be able to meet the academic and technical standards of a program with or without reasonable accommodations. Said another way, the person must be otherwise qualified. When a student with a disability poses a direct threat to the health and safety of others, that student is no longer considered otherwise qualified. But before an institution can make that determination, it has to employ, what we've come to understand as a direct threat assessment. And essentially, this is a process that demonstrates, if done correctly, right, that the institution has considered objective, factual information related to the student and the risk that is posed, and has gone through a process to determine whether or not the risk can be sufficiently mitigated. So institutions have to make an individualized and objective assessment about the student's ability to safely participate in programs and activities. Generally, we see this in sort of an involuntary withdrawal sort of process or procedure for an institution. In some of these instances, if, for example, there's a medical issue or a other significant life issue or behavioral issue, sometimes there's a process through which the student themselves is voluntarily agreeing to separate from the institution for a period of time, through a leave of absence or something like that. But if that's not the case and there needs to be a consideration of an involuntary withdrawal, this is the process then that must be employed before making that determination. And so when we consider kind of the compliance point here, when this team is convened, whether your institution calls it a behavior intervention team or a care team, making sure that there's that individualized assessment and documentation of it to evaluate the nature and duration and severity of the risk, and the probability that the risky behavior will occur, and again, making the determination in reviewing medical and objective evidence, and then considering whether reasonable accommodations or mitigation measures will sufficiently reduce the risk. So again, the process is to focus on behavior and conduct and objective evidence related to it, to avoid situations where decisions are being made based on prejudice or stereotypes about individuals with disabilities. And so if done, following this assessment process, then the institution will be able to have, kind of documentation and demonstration about how it made that determination. Again, there are various kind of OCR letters and resolution agreements related to direct threat assessment as well, for your reference. And with that, I see that we are at the top of the hour and therefore out of time. Marissa and I will review the additional questions that we didn't get to, and we'll respond to you. I want to thank you very much for joining us today. We hope the information was helpful to you and your institution as you're dealing with this really important work of focusing on disability compliance. Again, the program has been approved for legal education hours. To report your hours, you can click on the CEU icon, or it looks like we might have been having some issues with the CEU icon, but we will make sure to get you the information related to your credits. And be sure again to complete our short survey. We use your feedback again to help us plan really meaningful and helpful content for you all and your institutions. So thank you again. We hope you have a great rest of the week. Take care.